You are listening in to the Bar Defense 2017 Negotiated Rulemaking webinar series. This is the first of our series, and these are debriefing webinars. And what I mean by that, you know, we do a lot on this platform, or have in past years. It's been a little quiet this year. We've been real busy, but you know, we often will do what I'll call informational webinars that are open to everybody, and we're just trying to provide information. And that is the case here. We're happy for anyone to attend, but we have a little bit of a specific purpose. As some of you know, if you saw the webinar announcement, and I'm going to talk about all of this in more detail, but the Department of Education right now is in the process of rewriting these bar defense rules, and they're doing that through a process called negotiated rulemaking, which involves some folks that are selected as negotiators. And I'm one of those folks, so I'm at the table in D.C. trying to work with others to think about ways we can improve this rule. And each primary negotiator is appointed to represent a particular constituency. The constituency that I represent in this case are general counsels, attorneys, and compliance officers from institutions of higher ed. And part of my responsibility in that role is not only to try to speak well and eloquently for those folks when I'm in D.C. and we're negotiating the rule, but also to try to debrief and bring information back to the constituency. So we're doing two things here. One is we're trying to provide general information to anybody who might want to tune in, because it is important for the community, the higher ed community, to follow these rulemakings. But also, pretty specifically, if you're a general counsel or a compliance officer type at your institution, this is to debrief you and to help you understand what happened in the first round. And we're going to do 2 more of these webinars following each of the negotiated rulemaking rounds. And each time, that's going to be one of my primary objectives, is to let you all know what's been happening. And I want to add, if you have questions or concerns about the rulemaking or things you would like me to be thinking about prior to my next trip to D.C., please email me and let me know, because, again, I am here to represent you. Now, I've just given this big speech and I'm talking about myself, and I realize for some of you I have not even made an introduction. So let me stop and say my name is Aaron Lacey, and I'm an attorney here at a law firm in St. Louis, Missouri. It's a pretty big law firm, Thompson Coburn LLP, and I'm in our higher education practice. And we work with all different kinds of schools on all different kinds of things. I'm going to skip through this quickly because we spent a little bit of time trying to get the sound worked out. So you are very welcome to go back and look at these opening slides, but I want to get right to the presentation. I want to talk just briefly about, I'm a top-down learner, so I like to start at the top, the 40,000-foot level, and sort of work my way down into the details. So I want to just briefly comment on what's going on in higher ed in general, very briefly. But then I also want to speak to the bar defense origin story and get you up to speed on what's been going on with all of this. I want to talk to you about negotiated rulemaking in general, and then I want to really get into and give you a solid overview of last year's rulemaking. This is an unorthodox situation insofar as there was a rulemaking that addressed these topics last year, and now this administration has decided to redo it only 1 year later. So it's very important to understand sort of historically what has happened and the ideas that were on the table last year, because as you would expect, they are playing significantly into the conversations that are being had this year. I want to talk through this complicated timeline, and then at the very end, we'll go into a lot about what happened at the very first rulemaking session, and I want to walk you through sort of the issues that are on the table and some of the questions that were being addressed. It is my expectation that prior to the next round of rulemaking, we will get draft regulatory language from the department, and we'll really start to get more into the weeds regarding not just the issues, but specifically the way the department anticipates addressing those issues in the way of regulatory language. So I expect the next couple of webinars to get even more deeply into how the department plans to regulate in this area and the proposals that are on the table. This one, I'm trying to spend a little more time laying groundwork. Now, let me pause briefly because my producer is yelling at me in a very nice way. She's not yelling, she's wagging a finger. I need to run over some housekeeping. So this program is CLE, or Continuing Legal Education Certified, which means if you are one of those attorney folks out there who needs continuing legal education, this can count for you. We also have it certified for continuing professional education. Certificates will be sent in the days following the webinar. Please remember that for CLE or CPE credit, you have to log in with the same email address you used to register for the webinar. The login is proof of attendance and supports our awarding of the credit to you. If you need to leave the webinar, you should log out and then log back in when you return. If you are one of those folks seeking CLE or CPE credit, you need to verify your attendance. And the way you're going to do that, during the webinar, we're going to put up 3 top secret code words. And I will make sure to note them when they pop up. You should write those down because you'll need them to provide in your verification form after the fact. All CLE questions should go to, there's a web address. We'll send that around following the webinar. I don't want to read it off here, but we've got an email address that you can email them to, and I'll also give you a phone number. This webinar, I've timed it out. It's going to go a little north of 60 minutes. We set aside 90. It'll probably run 60 to, 75, but I wanted to try to build in time for questions. I'll respond to the questions at the end of the webinar, and we'll try to stay on even beyond the 90 if I need to, if there are that many questions, because I really want to try to get things answered. Also, please remember that if you're listening to this at some time after the original air date, so if you're tuning in and it is 2025, it is possible that the law and guidance has changed. Also, you should call me and let me know that I need to pull down a webinar that's old. Finally, an electronic survey form will be sent following the webinar, and we always appreciate folks filling those out and giving us their feedback. So I mentioned at the outset, it's busy times in higher ed. I mean, I really take the view that this is a watershed time. I'm not going to go through all of these different topics, but it's important to appreciate that even when you have a rulemaking like this, it's not happening in a vacuum. And the one thing I will note here that I expect most of the folks on the call are aware of is that we are now sort of for realsies in the midst of the reauthorization of the Higher Education Act, right? So Congress is also thinking about reauthorizing, the primary federal law that governs certainly student federal aid, but a lot of other pieces of higher education that are addressed at the federal level are wrapped into that act as well. And may, as part of this reauthorization process, decide to include new legislation or make revisions to existing legislation, and that could impact the department's authority or ability to regulate in some of these areas. You see right now, we've got revision of Title IX policy on the table, revision of the bar defense rule, which is what this webinar is about, also revision of the gainful employment rule. Is happening at the same time. So, it's interesting. We're going through this exercise of rewriting these regulations, but just keep in mind that at the same time, the statutes are being reconsidered. And so what we're doing here could ultimately be impacted by the new Higher Education Act or the changes to that Higher Education Act when it's reauthorized. By the way, I think we believe it is optimistic to hope that the HEA is reauthorized in 2018. That's next year. We think more likely even as 2019, but you never know. We'll see. The folks in the House seem pretty interested in moving things along right now. So the borrower defense origin story, and I'm going to start sort of focusing more specifically on borrower defense, the actual borrower defense statute and rule. As those of you who've tuned into our prior webinar series on this rule and or otherwise are plugged into it, you know that in the context of under the umbrella of the borrower defense rulemaking, there are a lot of other ideas that are being considered. And I'm going to show a slide in a minute that'll talk about that. But let's, from a sort of regulatory standpoint, let's just start by focusing on the borrower defense rule itself and what we mean by that. So in 1993, Congress created the direct loan program. That's going way back, right? And as part of that legislation, they directed the Secretary of Education to specify in regulations. So sometimes Congress does this, right? They don't actually spell everything out. They'll just direct the Secretary of the agency to promulgate regulations that get into certain things. And in this case, the Congress told the Department to come up with some regulations and specify which acts or omissions of an institution of higher education a borrower could assert as a defense to repayment of a loan made. So just to be real clear, what we're talking about is a borrower, a student, former student, graduate takes out loans. What is it that they could say to the department when the department goes to collect on those loans that an institution did or didn't do that would get them, I don't want to say off the hook, but that would obviate the need for them to repay those loans. So in other words, they would go to the department and say, look, I owe you $10,000, but my institution did X or Y, and because they did X or Y, I don't think I should have to pay back those loans. And so what Congress was telling the department to do is to specify what exactly X and Y would need to be. And this, importantly, was put in the statute a long time ago, right? 25 years ago. Hard to believe that. The following year, the department introduced in the regulations, and here's the site, 34 CFR 685-206C, this sort of basic framework. And this basic framework, I have on this slide that it still exists today. And we're going to get into this in more detail in a little while. So this was put on the books, right? And then last year, the department went through a rulemaking process, and there were new regulations that were promulgated November 1st that were set to become effective July 1, 2017, which would have replaced this regulation. But the Department of Education, under the new administration, prior to July 1, 2017, said, we're going to suspend that new rule, or we're not going to allow it to become effective. So what that means is, while we did go through a rulemaking process in 2016, and there is a broad, complex new rule that's out there, it's sort of floating in purgatory, so to speak, and this rule does still remain on the books and is at least considered to be, at this moment in time, good law. So the framework that was created, the department would initiate a collection proceeding, right? So you've got a student who owes some amount on the loans and isn't paying those amounts back, and the department says, okay, we're initiating a process to collect. And then the borrower would assert a defense. And that's what I was talking about earlier. It would say, you know, the school did X or Y, I shouldn't have to pay it back. The department would consider that defense and decide whether or not to forgive that amount. And then separately, and this is a really important point that's going to play into some of our conversation later, separately, the department would determine whether or not it wanted to pursue the institution to try to recover those amounts. So step one is the department speaks with the student and says, you know, we think you owe us this amount. Student says, my institution did X or Y, I shouldn't have to pay it back. And the department considers the facts and then may say, okay, we're going to discharge that $10,000 so you don't have to pay it back, right? And then the department has this option of turning around and saying to the institution, we want you to pay back that $10,000. This is a really important link. For those of you who have not been following this rule or may not understand that, or have understood the implications, I mean, from an institutional perspective, this is why this is also critical. It's not just about what are the circumstances and processes by which the department could discharge a student loan. It is also about the circumstances and processes under which the department could then turn around and require the institution to pay back those amounts. Right? And if it's one student and it's $10,000, that may not be attention-getting, but if it's 400 students and it's $7.8 million, now the institution understands that there's some risk involved. So that's why institutions should really be plugged in and paying attention to, and certainly the risk managers at institutions, meaning those general counsels and attorneys and compliance officers, should be paying attention to this rule. If you're a financial aid professional and you are listening in right now and your general counsel does not yet appreciate that this rule is not so much about financial aid, but it is about risk and processes and claims and proceedings, I encourage you to go talk to them about that, because my experience right now is, even when I talk to a lot of general counsels, their initial reaction when we were talking about this webinar, they say, oh, I'll let folks in my financial aid office know that you're doing that. And I said, well, that's great, and I would love for them to listen in, but you should understand that what we're talking about here too is liability and risk and claims and statute of limitations and standards for fraud, and those are all kind of attorney concepts. So I encourage you, if your attorneys and compliance officers aren't plugged in, to consider letting them know and getting them plugged in. One important note here, under the current law, the department has 3 years to initiate a separate action to recover. So there's no statute of limitations at present on when a borrower can bring a claim to discharge their loans. In theory, even after their loans are paid off, they could still try to bring a claim and then get that paid back to them, right? But there is a current limitation on how long the department has to turn around and then try to recover from the institution, and that's 3 years. A bar defense could include any act or omission of the school attended by the student that would give rise to a cause of action against the school under applicable state law. So breaking this into sort of layman's terms, what that means is, if a student or a borrower could show that whatever the school did would give rise to a cause of action under state law. In other words, the same person could go into court in the state and argue that the school violated some state law, then the department is saying, okay, that's a basis to discharge a bar defense. Of course, the challenge then is, that means you've got people at the U.S. Department of Education trying to decide whether or not something a school did or did not do is a violation of some state law that the folks at the department may not have familiarity with. And this is complicated, and the department has already acknowledged that this is sort of a problematic standard and was one of the reasons they wanted to go back and revisit how they were approaching the whole bar defense concept. In 1995, the department came along and provided some additional guidance, and they said, you know what, it's not enough that it just give rise to a cause of action under state law, although that is all the regulation stated. But in the guidance, the department added and said, you know, the cause of action needs to directly relate to the loan, or to the school's provision of educational services. That's still a pretty broad umbrella. Most of what schools do could be tucked under the school's provision of educational services. But what the department was trying to carve out, you know, and you have a couple of examples here. For example, injury tort claims. So slip and fall. Somebody slips in your parking lot. That should not be a basis for discharging their student loans. It might be a basis for them to try to sue you in state court or even give rise, and they could even be ultimately victorious. But again, that's not a basis for them to discharge the loan. A basis to discharge the loan needs to relate to either the loan or the educational services provided. With regard to timing, I mentioned earlier a bar could assert defense at any time, but the department only had 3 years. Again, these statute of limitations concepts are important, particularly for risk managers. So you compliance officers and general counsels understand that these are important concepts, as do, I'm sure, others on the phone who may not fill those roles. So there was no discussion of the process the department would follow in a recovery action, sort of remarkably. And this is back, you know, in 93 and then in 95. All the department said in that 95 guidance was, well, schools are entitled to due process in these proceedings. So they acknowledged that there needed to be some form of process. And many of you know that the fundamental concept in due process is that someone has notice of the allegations against them and an opportunity to respond to those allegations. That's sort of the tent poles of due process. So here's really the money slide, as they say. I mean, prior to 2015, so between 1993, right, when the HEA was reauthorized, and then you had that 95 guidance and the regs put in place, over that 20-plus year period, the department received 5 bar defense claims. Here we say defense to repayment. I've seen this BD, BDR, DTR, all the same thing. But the department received 5 claims from students, right? As of June 24, 2016, they had received almost 27,000 bar defense claims, and they had actually discharged north of 73 million with an additional 98 million in closed school discharges, right? So you can see they suddenly had a problem. They had a very brief and, to say the least, process that was put in place, some sort of nebulous concepts, and now they had 27,000 claims that they had to adjudicate. As of August 15th, 2017, that had gone up to north of almost 99,000 bar defense claims. Now, it's worth noting that 89% of these, based on the information from the department, relate to only 4 schools. So there you know, a lot of the concern is around these 4 institutions, 2 of which are now closed, and the conduct that they engaged in and that kind of thing. But the fact is, the department realized when this occurred that times had changed. And on a go-forward basis, it may be more than 4 schools, right? And it's not just schools in one sector or another, and I want to point that out because that's really important for the folks who are from public and nonprofit institutions to appreciate, and there are many on the line today. This is for any school, so anybody that may go out of business or have a location that goes out of business or close a program or have anything on their campus that could ostensibly cause student concern, that could lead to bar defense actions. And so the department said they needed to put a more robust process in place. So here's your first secret word. Here's your first secret word. It is revision, in the spirit of revising the rules. Okay. So let's talk about what the department decided to do in 2016. They decided to go through this negotiated rulemaking process, which is how the Department of Ed and a handful of other executive agencies make rules. Just to give you the basics, and they made this decision in 2015. It was announced in the Federal Register, which is typically how they do it. And they said, look, we're going to initiate a new, quote, negotiated rulemaking, and we're going to come up with what I have labeled BDR2. So BDR1 is what we just went through. These are not Star Wars characters. These are versions of the regulation. BDR1 is what we just went through. BDR2 is what the department decided to try to put into place, or did put into place last year. The purpose of negotiated rulemaking, for those who may not be so familiar with the process, is it's a framework through which, in this case, the Department of Ed can develop a rule in collaboration with representatives of groups, right, as opposed to doing it behind closed doors on their own. So it was really designed to promote transparency and also to facilitate input from regulated constituencies. And it's done through a series of meetings during which the selected negotiators work with the department to achieve what is called consensus. And I'll talk about that in a minute. But that's where everybody at the table agrees on something. So it has to be, it's like the UN, it has to be unanimous across all parties, or at least all the primary negotiators. You have typically one federal negotiator, which means someone from the department actually has a seat at the table, as you would expect. And then you have usually 15 to 20 other individuals who all represent different constituencies. So in this case, you would expect folks there who represent institutional interests, folks who represent student and consumer interests, attorney generals, folks from guarantee agencies, financial aid professionals, all those different types of individuals who might have a stake and an understanding of this rule. This is an action shot. I thought you guys would appreciate this. It is truly as exciting as it looks, I have to tell you. But this is a real deal. This is from session 1. So you can see the action as it was transpiring. The selection of negotiators, the department solicits nominations through the Federal Register. And I mentioned after reviewing those nominations, the department actually appoints usually 15 to 20 people. There is a cap in the law on the number of people that can participate. What's interesting is committee members can actually suggest additional negotiators once the sessions begin, and in this case that happens. So the department had made a call for negotiators representing a range of constituencies, and the one constituency that was not filled, and I can only presume no one was nominated, so the department didn't appoint anyone, was someone representing state higher education executive agencies, right? So that's the regulators, the state regulators. So during our first session, I forget it was on the first or second day, we came to that point where there was an opportunity for other individuals to petition to be a member of the committee. And sure enough, the current executive director of SHIO, which is the sort of blanket organization that represents all those state education agency officers, was there and stood up and said, I'd like to be considered for membership, and was approved. So he is now a member of the committee. Determination of issues. So, and this is important, right? And this really can change from administration to administration. The department doesn't just show up at the negotiated rulemaking and sort of throw it to the negotiators to come up with a rule. They don't just say, well, we got a problem, so how do you think we ought to do it? I mean, they come to the table with specific issues they want the negotiators to consider, and they gather that feedback, and that's largely what we did during the first session. And then the department will even start often, I don't know that they're required, but typically will start providing draft regulatory language. So they gather that general feedback on the issues and the opinions, and then they'll start putting out that draft language. What's important to note is there is some ability of the department to direct the thinking just in the issues that it selects for discussion and the way that it presents certain questions, right? And then, of course, when it actually starts to create draft language, it's taking into account all of that information that's been provided in the first session typically, and it's sort of synthesizing what the administration believes would be an appropriate approach. So there is a lot of opportunity from the department side of things to direct the consideration. Again, the negotiators have also ample opportunity to provide input, but how the department frames the issues for discussion and how the department frames and drafts up regulations for consideration, as you can imagine, goes a long way to directing the final product. Possible outcomes. So if consensus is achieved, the department pledges, interestingly enough, I do not believe they're actually required under the law, but as part of the protocols established for the negotiated rulemaking, the department agrees that if consensus is achieved, it will use the regulatory language that is agreed upon in the proposed rule. In the absence of consensus, and remember, consensus requires everyone at the table agreeing. That doesn't have to be on every concept, right? But on a given concept, to say you had consensus on that concept, right? Everyone has to agree. If consensus is not achieved, then the department can actually elect to terminate the rulemaking. They can use the regulatory language developed during the negotiations, or they can develop new regulatory language for all or portion of the proposed rule. And consensus is tough to get, even if you have a lot of agreement on a lot of different aspects of the rule, as it would not surprise you, when you've got 15 to 20 people sitting around a table who all represent different interests, it can be a real challenge to get everybody on the same page. So there needs to be a mechanism, obviously, for moving forward, and that's what this is. But typically the department will take into account a lot of the feedback that's been received in addition to their own agenda, and then they'll come up with a proposed rule for consideration. All right, so let's talk about borrower defense 2. And again, this is the rule that was put into place last year. I have a timeline later on that I'm going to go through, but a couple of notes I'll make now. One is, so the department went through negotiated rulemaking for borrower defense last year. They did not achieve consensus. So the rule that you got incorporated elements from the negotiated rulemakers, but was the department's own invention. And then that is, as is typically the case, they have proposed rules that they'll put out in the Federal Register. So you conclude the negotiated rulemaking, and then the department, if you don't have consensus, goes back and creates some proposed rules. Then they'll put those in the Federal Register, publish them for comment. Then you have a period where people can comment on them. That's typically over the summer. And then that period will close, and the department will review all those comments, and then they will issue their final regulations, right? And according to what's called the master calendar, the department has to promulgate regulations by November 1st of a given year in order for them to become effective by the following July 1. So they went through this process with the Borrower Defense 2, BTR 2 last year, and you'll often notice that a lot of the department's regulations come out on Halloween or November 1st. This is why, because they're trying to hit that deadline. So last year they promulgated this big rule package on November 1st, and again it was set to become effective July 1 of this year, 2017. Now what's interesting, and a very important point, is that when we, the negotiators, showed up for session 1, the department said, the level set, they said, we are not here to revise BTR 2. In other words, our starting point is not the BTR 2 regulations. Instead, what the department said was, our starting point is essentially BTR 1, and we're going to set aside the suspended BTR 2 regulations, right? And I will also note those regulations as of right now are officially suspended through July 1, 2018, and the department has proposed to suspend them all the way through July 1, 2019. If they were suspended through July 1, 2019, that would be the earliest date that BTR 3 could become effective. So if they end up suspending BTR 2 all the way through July 1, 2019, there would essentially be no gap, or there would be no period at which BTR 2 became effective. It would have been suspended for that entire sort of interim between July 1, 2017 and July 1, 2019, and then you would essentially go from BTR 1 straight to BTR 3. Right, and that appears to be the department's intention. At least it was my impression that that's what they were communicating during the negotiated rulemaking. But, so you say, well, Aaron, if we're skipping BTR 2, and the department said the exercise here is not to go back and rewrite BTR 2, but to sort of put everything back on the table, why should we be looking at the BTR 2 rule and how it developed? Because, and I will tell you why, because while we can say we're starting with BTR 1 and we're reconsidering all the issues and putting everything back on the table, the fact is BTR 2 did happen. And all of the ideas and concepts and arguments that surrounded that negotiated rulemaking are out there. And they are known, right, to a lot of the people around the table. So that when we began discussing many of these issues in the context of the current negotiated rulemaking, it was inevitable that people would refer back to last year's negotiation and the ideas and the concepts that were out there. I don't think there's any way that you can plug into the current round of negotiated rulemaking and appreciate what's going on if you don't have some notion of what happened last year. So that's why I wanted in this session to go through BTR 2 and lay some of that groundwork, understanding that in our next 2 webinars we'll focus more on the conversations involved in this round of negotiated rulemaking. Although don't worry, I'm not going to do all 90 minutes on last year's negotiated rulemaking. I'm definitely going to get to what we discussed in session 1. All right, so one of the points I made earlier is that while borrower defense is sort of the headlining concept, and that's what I walked through a minute ago, there are other ideas that have been wrapped into this negotiated rulemaking and that were discussed last year and actually made it into BTR 2, the regulations. So at the top was, you know, how does a borrower go about saying that their school did something that would justify having their loans discharged. And that's the real bar defense piece. But in addition to that, last year, as part of BDR2, the department rolled out regulations that altered financial responsibility and created certain what I'll call triggers. That's the word that's often thrown around, which meant that if certain events happened, you had to report them to the department, and that could result in recalculations of your composite score, letters of credit, and other types of action. Again, I want to emphasize this is not restricted to any sector of higher education. This affects all sectors of higher education. Understanding that public institutions are able to establish financial responsibility through alternative means. Arbitration agreements were on the table, largely thought of as being an issue for the career schools that tend to use enrollment agreements and arbitration clauses, but again, it's worth noting that a lot of traditional institutions will have little arbitration agreements, maybe in the contract they have with students so they can use their gym and athletic facilities. They may have something like an arbitration clause, a pre-dispute arbitration clause or class action waiver, and certain other types of agreements or ticket stubs, all different little places that schools and students may have little contracts that include those, even in the traditional side of the house. There were revisions to the closed school discharge and false certification discharge regulations. So those are two other event-related discharges. As it sounds, you know, in the first bucket for closed school, the department thought about, well, what constitutes a closure and when could a student, if a school does close, seek to discharge their loans. The really important point I'll make on this, I'm going to talk about a little bit later on. The real focus here for me is going to be on bar defense. But one of the things schools sometimes don't appreciate is that closed school discharge is potentially available even when you're closing an additional location. So let's say you're a large private nonprofit institution and you've got locations on military installations or sites around the world. Every time you close one of those additional locations or branches, those students potentially could be eligible for closed school discharge depending on how that closure plays out, right? So this isn't just about a main institution closing. The closed school discharge provisions can apply even when branches and additional locations close, which means they have much broader implication than sometimes people think. False certification right now, at least in the regulation, and this is something else, you know, if you're a financial aid staffer at an institution, and I've seen this many times when I've worked with schools over the years, you know, you'll get a call from, it's usually not the department, it's a contractor, and they'll say, oh, we have an application for false certification discharge. Someone is saying X or Y. Sometimes a borrower, it will be essentially alleging that their school did something wrong or wronged them in some way. But the point I want to make here is if you look in the regulation, the bases for a false certification discharge are actually pretty limited. That your school didn't do a good job teaching you is not a basis for a false certification discharge, right? Even though sometimes the department and their contractors will entertain those types of allegations when a false certification application comes in. Of course, the first thing I always ask is, well, which bucket in the regulation does this fit into, right? So one of the things the department is reconsidering is whether or not to broaden what could be deemed a false certification discharge, and obviously that has implications for institutions as well. And then the department thought a little bit about their definition of misrepresentation and finally introduced a repayment rate concept for proprietary schools that does not appear, by the way, to be on the table this time around. That seems to be completely off the table. So there was a lot that the department was thinking about when they were doing BDR2 last year, and that was addressed in the context of that rulemaking. It was a very large and complex rule. Let's talk specifically about some of the changes that were made to the bar defense piece of it, right? So a minute ago, I walked you through the original BDR1 framework, which was pretty simplistic. These are the changes that BDR2 made to that framework. So first of all, there was no collection action that was required, right? Under the original framework, really what was envisioned was the department would be trying to recover or collect from a student on probably a default, you know, or something along those lines. Clearly the student's not making payments, and that's why there's a proceeding. And then the department, the student could assert as a defense to repayment, right? In the context of that collection action, it's a defense. And they could say, oh, my school did X or Y. One of the things the department did last year is they said, you know what, we don't have to move forward. Moving forward, we don't think that we need to have initiated a collection action, right? If a student thinks that they're eligible for a discharge because their institution did something to them, they should be able to just go online and fill out an application. You know, I will say this matter was brought up in the context of Session 1 just a few weeks ago, and most people, including most institutional representatives, tended to agree on this point, that you shouldn't have to, a student shouldn't be forced into not repaying their loans or entering default so that they could assert a borrower defense, right? So my expectation is moving forward, this piece will probably stay the same. Judgment, breach of contract, and substantial misrepresentation were advanced as new federal standards for a borrower defense claim. So this is a really important point. Remember, under BDR 1, in order for a borrower to assert a defense, they had to show that whatever the school did gave rise to a cause of action under state law. And I mentioned earlier, you know, just practically speaking, the department's looking at these 90,000 borrower defense claims, and what they've got to do is try to figure out if the allegations violated a state law in each state. And then there's the question of, well, what state are we even talking about? Is it the student's state of residence? You know, is it their current state of residence, where they were residing when they were in school? Is it where the school is located? What if they were an online student? I mean, it gets really complicated. And so one of the things the department suggested with BDR 2, and I think there is momentum, and you're going to see it again in the context of BDR 3, is inventing a federal standard that they have the authority to determine without having to make any reference to any sort of state law. So last year, they, as part of BDR 2, they created a federal standard, and in fact 3, and we'll walk through those in a minute. New time limitations on asserting a claim, and what I really mean is they came up with sort of a new set of statute of limitations concepts surrounding, 1, when a borrower could assert a claim, and 2, when the department could then seek to recover monies from an institution. And in most cases, it was a pretty complex framework, and in most cases, it created additional flexibility for the department and for the student, as opposed to BDR 1. New time limitations on recovery actions, I mentioned that. New individual claim process and a new group claim process. So there are a couple of concepts here. First is the department introduced for the first time, because you remember BDR 1 didn't really get into this. The department introduced the process pursuant to which a borrower would seek to get their loans discharged. How do we really go about adjudicating it? What does the department do? What's the back and forth? But the other thing they introduced with this was the idea that the department could, on its own initiative, and without any borrower having actually filed for a discharge, the department could initiate its own process. So in theory, you know, the department could say, we have information or combined information or what have you that leads us to believe that a group of borrowers is eligible for a discharge. Now, none of that group has actually applied yet, but we're going to initiate a process and assign an attorney from the department staff, and we're actually going to bring a group claim, sort of like a class action, against the institution to discharge those loans. And even in BDR 2, I could see some people at the negotiating table taking issue with my characterizing that as a proceeding against the institution. I think if you are an attorney that represents institutions, most of us uniformly would say the point at which an agency initiates a process that could result in a liability for the institution, I mean, that is a claim against the institution, even if, as a technical matter, you know, there may be a first stage that involves the discharge of the loans. Not everyone would agree with that view. Finally, new methods for calculating relief. So the other interesting concept was, you know, the department acknowledged that a borrower could have a valid claim and there could be a judgment that the borrower is entitled to some discharge, but it might not be all of the loans. And so they talked about how they might determine and the criteria that might be used to determine whether and to what extent the loans would be discharged. So, you know, if a borrower had a valid claim, but it turned out that there was very little harm done, the idea was that an administrative law judge or a staffer, depending on who was considering the matter, might not discharge all the loans, but a smaller amount. There were some pretty interesting ideas in there. I mean, some of them had to do with the department essentially making a determination as to the value of the programming that the institution offered. And that kind of thing made me, as an institutional representative, very uncomfortable because I think that that would be extraordinarily subject to potentially political or other bias, right, depending on who's making that determination and what they may feel about certain types of institutions and the education they offer. So let's just break down briefly, and I don't want to spend too much more time on BDR 2, but I do think it's important to understand the complexities here because a lot of that is on the table again in this current negotiation. So I mentioned earlier they came up with this new federal standard. And what BDR 2 says is that a borrower defense exists where an act or omission of the school relates to the making of the loan or the educational services it provided. So they took that 95 guidance and made it part of the reg, and was the basis for a judgment against the school, was the basis for a breach of contract, or constituted a substantial misrepresentation. Now, the first of these, the judgment, I think is fairly non-controversial. I mean, there may be people who feel like we shouldn't have a federal standard, and there may be people who have strong opinions about the extent to which that judgment needs to be contested, et cetera. But, you know, the idea that if a student or a borrower actually had a judgment from a court in hand and showed up that said, yes, see, the court decided that the school broke the law and it's a bar defense claim, most folks seem to agree if it was a contested judgment that that's a pretty reasonable standard. Now, in terms of the statute of limitations, the BDR2 had no limitation on when that claim could be brought. So, you know, a borrower could get a judgment and wait 20 years and show up and bring the claim, which some institutions might object as being an unreasonable statute of limitations, and I think that there's an argument there, at least for consideration. The other question is whether or not the judgment has to be from a court or it can be from an administrative tribunal, and what exactly constitutes an administrative tribunal of competent jurisdiction. Because I think it's one thing if a federal court has a judgment and a borrower shows up with a federal court judgment. It's another thing potentially if a small agency in a particular state has a determination that may or may not have been reached through the type of fulsome process that you would expect, say, in a federal court proceeding. So there is some question there. Breach of contract. So this included any failure to perform under terms of contract with the student without regard to materiality. So to be clear, if there was a breach of contract and it related to the educational services provided, and most of what schools do relate to the educational services provided, then a student could argue that that was a valid basis for a borrower defense claim. And there's no materiality standard, so it doesn't matter how significant the breach was, nor is there any materiality regarding the detriment or harm that was experienced by the student. So if you're an attorney type, these are all things that raise an eyebrow. The other thing that raised an eyebrow for many was, and this is BDR2, remember, the department took the view that a contract could include an enrollment agreement and any school catalog, bulletin, circular, student handbook, or school regulations. So just to be clear, if you are a large private nonprofit university and a student says your catalog indicated that tutoring was supposed to occur on Tuesdays and Thursdays, you didn't have enough grad students, so the tutoring instead occurred on Wednesdays and Fridays, at least in theory, a borrower could argue that that was a breach of contract. Catalog constituted a contract and it was a breach. Now, there would presumably be some consideration on the back end as to whether or not that was really material and as a consequence, the extent to which any loan should be discharged. But at least on its face, that would have constituted a valid borrower defense claim under BDR2. There was no limitation on claims to discharge future amounts owed and a 6-year limitation from the date of the breach on claims to discharge amounts already paid. The last bucket, though, and the one that no doubt creates the most concern and should for institutions if you're a risk manager, is substantial misrepresentation. Now, when we hear a substantial misrepresentation, I think for non-lawyers, folks outside of education, you think, well, okay, I mean, yeah, if you're substantially misrepresenting something to someone, that sounds like that's pretty bad, and that should be a basis for a borrower defense claim or, you know, some sort of recovery. But of course, the detail, or the devil is in the details, right? And the question becomes, well, how do you define substantial misrepresentation in the context of these proceedings? So from the borrower defense standpoint, what the department says, it includes any substantial misrepresentation made by the school or any contractual partner. So it doesn't have to be by the school directly. It could be by anyone who might be contracting with the school. So any vendor that a large institution might contract with, any representation they might make. And there's no materiality standard. Now, there are folks who I have no doubt who were involved in this process last year who would disagree with that, because a borrower did have to show actual reasonable reliance to his or her detriment. And I think folks would say, well, that's your materiality standard. I mean, there had to be actual reliance to their detriment, except in group claims, by the way. In a group claim, there was a presumption that borrowers had actual reliance, right? And there was no limitation on claims to discharge future amounts and a 6-year limitation from the date of discovery of the misrepresentation. So fairly flexible statute of limitation standards. But let me show you why this was so disconcerting and why a lot of folks in the higher education community were vocal regarding this particular standard. So there is a definition in federal law right now of misrepresentation, right? This is the definition of what constitutes a misrepresentation. And I know this is violating the rule of not putting too much text on a slide, but I'm going to read this because it's really important. And the only distinction, the only thing that the department changed in the context of BTR 2, where they added the red print and they took out that one word that I've got struck, deceive. So to be clear, if you imagine this slide without that red print and with deceive, that's current law. This definition is in current law, right? A misrepresentation is any false, erroneous, or misleading statement an eligible institution, one of its representatives, or any ineligible institution, organization, or person with whom the eligible institution has an agreement to provide educational programs or to provide marketing, advertising, recruiting, or admission services, makes directly or indirectly to a student, prospective student, or any member of the public, or to an accrediting agency, state agency, or the secretary. So for starters, let's be clear, this includes any false, erroneous, or misleading statement that any vendor, anyone you have an agreement with, might make to any member of the public, right? Not just a representation that you as an institution would make directly to a student or employee or someone like that, right? A misleading statement includes any statement that has the likelihood or tendency to deceive, and I'm just going to go with current law. And a statement is any communication made in writing, visually, orally, or through other means. A misrepresentation includes the dissemination of a student endorsement or testimonial that a student gives either under duress or because of the institution required the student to make such an endorsement. Okay. But the key point I want to make here is a misrepresentation under federal law, existing federal law, can include, again, any statement that you or any vendor might make to any member of the public that has a likelihood or tendency to deceive. What I typically tell my clients, my institutional clients, is just to assume that anything you say, by the way, it's directly or indirectly, I just tell them assume anything you say could be characterized as a misrepresentation, because trying to defend against this standard is very challenging, right? Very challenging. So then the question becomes, if virtually anything we or any vendor says could ostensibly be construed as a misrepresentation, well, what's a substantial misrepresentation, right? Because that's the key concept here. This is also in current federal law. Any misrepresentation on which the person to whom it was made could reasonably be expected to rely or has reasonably relied to that person's detriment. Now I want to point out a couple of things. First of all, to be a substantial misrepresentation, setting aside the bar defense standard for a minute, under federal law, for the department to determine that something you did was a substantial misrepresentation, it only requires that a misrepresentation, you remember how low that standard is, the one I just read, that a misrepresentation be one upon which a person could reasonably have been expected to rely. So it doesn't even mean that they relied on it. It means you had a vendor who made an indirect statement that had a tendency to deceive, and someone says, well, I could have reasonably been expected to rely on that, even though I did not, to my detriment. Also want to point out, there's no intent or recklessness required, and there's no requirement that the misrepresentation or the detriment be material. So that person could say, you know, that statement that was made that had a tendency to deceive, your vendor made it indirectly to me, and I could have reasonably been expected to rely upon it to my detriment of $5. That's a substantial misrepresentation, you know, just to be very clear. So the standard here to achieve substantial misrepresentation is much lower than what people might otherwise think. You often hear in the press and in conversations around bar defense the idea that these rules are about fraud and protecting students from institutions that have defrauded them. But it's important to note that there is a significant distinction between the typical definition of fraud that exists in most states and what you have here. This is not a fraud definition. This is a mistake standard. It's a mistake definition. And if you think there is any question on that point, this was a quote from the Federal Register that the Department provided during the BTR 2 negotiated rulemaking. We believe that an institution is responsible for the harm to borrowers caused by its misrepresentations, even if such misrepresentations cannot be attributed to institutional intent or knowledge and are the result of inadvertent or innocent mistakes. Similarly, we believe this is the case even for statements that are true but misleading. So to be clear, you could, without knowledge, make a true statement, right? And the department is taking the view here that if that caused harm to a borrower, that should be a basis for a borrower defense. Again, if you're a financial aid rep and your general counsel got our announcement and said, why don't you go, this is the kind of thing they should really understand, because if I'm a risk manager at an institution, this keeps me up at night, right? And this is what's on the table right now, what we're talking about. Okay, so what about the process? So under BDR 2, that was the claim that had to be established. Now the question is, if somebody comes and establishes that claim, how does the process work for adjudicating the claim? So remember, there were two processes. One was individual and one was group. Under the individual claim process, the department basically had a two-stepper. And all of step one is those first, 7 boxes. And then step 2 is the box in red. So step 1, a borrower would just submit a claim on an application. So remember, there doesn't have to be some prerequisite or predicate a collection proceeding by the department. The borrower just files an application. The department would automatically grant forbearance, suspend collection activity, and then they would designate a staff member, not an administrative law judge, a staff member at the department. And the staff member would notify the school of the claim, but there are no guarantees with regard to whether or not the school will have an opportunity to provide feedback or whether that will be considered, et cetera. The staff reviews evidence of departmental records in any school submission. They're not required to, but it says that they will. Upon request, the staff provides the borrower evidence that the department deems relevant. The school does not have an opportunity to request what evidence the department deems relevant, or an opportunity to request, I shouldn't say they don't have an opportunity, but they don't have a right to request or receive even the allegations or the evidence that was provided by the borrower. And staff issues a written decision and notifies the borrower. Interestingly enough, there was also nothing in the regs that guaranteed that the school would be notified. But then after all that happened, secondarily, the department would initiate a separate action against the school to establish liability and recover amounts of pursuant to, and I've got a regulatory site here. Now this is a really important point I want to make, and it's going to come up in the timeline later. So the department promulgated the bulk of the BDR 2 last November 1st, so that it could become effective by July 1 of this year. But it had not yet articulated in a fulsome way how recovery actions against institutions, I don't mean discharge of the loan from the borrower, but how after discharge was granted, the department would then turn around and recover from the school, what that process would look like. And the department on November 1 said, you know what, we're going to do this in a separate document. So in January of this year, just prior to the change in administrations, the department issued a new set of regulations. And what they did was they changed the set of regulations that currently govern how the department makes decisions on program reviews, right? And those types of proceedings. So they altered those regulations to include a process, and it's a pretty fulsome process, with regard to how the department would recover against institutions. Here's the really important point I want to make. Those regulations that were promulgated in January became effective immediately. They did not have a July 1 effective date. So the regulations that the department promulgated in January of this year that govern how the department would recover from a school amounts that it has discharged under a borrower defense claim, those regulations are effective and they are in the law right now. And if you go look them up, you'll see it, right? And when the department prior to July 1 suspended the quote borrower defense rule, they did not suspend the January regulations. They only suspended the stuff that was promulgated last November. So what's interesting is BDR 2 is not on the books. It's been suspended, right? But we do have the new procedural regulations that were put on the books and effective immediately in January that govern how recovery actions against schools will be carried out. And here's what's really interesting. So the department has indicated that those 90,000 claims that are outstanding right now, they're trying to get to those right now. And they're not going to get to them under a BDR 2 standard. They're going to process them under BDR 1. Presumably, some of those claims will be considered valid and there will be large amounts that are discharged, right? Because you got a lot of claims there and a lot of dollars on the line. When the department, if and when it then decides to turn around and try to recover from an institution, it will do it under the regulations in that red box because those regulations are effective right now, right? At least that's the current state of the law. A borrower could request reconsideration at any time on new evidence, and then the department could reopen a claim at any time. So there was a lot under BDR 2, there was a lot of flexibility even after a decision had been made for the department to revisit it or a borrower to get something reopened. What's interesting is schools were not granted the opportunity to bring forward new evidence and to argue for the reopening of a claim. The department also could initiate a recovery action against the school at any time for claims based on judgments. Okay, these are the statute of limitations that we talked about earlier. Here was the group claims process, and this is the one I mentioned earlier that the department could initiate it on its own. So you'll see in the first box, the department will actually initiate a claim on behalf of a borrower group without regard to whether those borrowers had actually filed a claim or not. And then the department would designate staff, which would mean an attorney likely in the department's Office of General Counsel, to represent that group, and you would go in front of an administrative law judge. The ALJ would consider the evidence and the argument from the parties, feel much more like a court proceeding, right? Institution could request a hearing, all those kinds of things. And then the ALJ ultimately would issue a written decision on both the discharge and the money owed by the school. So remember, for individuals, it was a two-step. You had the first part of the process in which a borrower and the department, more or less, without the institution's significant involvement, determined whether there would be a discharge. And then secondarily, you had a recovery process. Here, it's all wrapped into one, right? Now I will tell you, I've argued that whether it's an individual borrower claim or a group process, that it should always go to an ALJ, and that it should be a single process. Because, again, I made the point earlier, I believe that the institutional interests are there from the beginning, right? I also think it creates exposure to the taxpayer if you've got, you know, a staff member or some other party making determinations on the facts and discharging the loans, and then you have a secondary process that is much more robust and fulsome in front of an administrative law judge. It creates the potential for and that for the first time involves the institution in a meaningful way. It creates potential for an administrative law judge to say, well, I know we discharged all those loans, but I don't think that there's an appropriate basis to go after the school, in which case, you know, the department has discharged the money and you can't recover it from the school, which means, you know, who's paying for that? The taxpayer. The other concern I had, and this is sort of a legal guy concern, but is the value of precedent in a system where you've got staff members making determinations on the facts and then administrative law judges. I mean, if a staff member makes a decision, does that bind the administrative law judge? If the administrative law judge makes a decision and then there's subsequent claims on the same fact pattern, does that bind the staff member? I think it creates challenges there as well. So for various reasons, I think I've sort of argued for a single process, and I think there are others at the table that feel that there might be some merit there as well. This was an interesting concept under BDR2, which I thought was problematic. If relief for the group was denied in full or in part, a borrower could still bring an individual claim based on the same underlying act or omission. So to be real clear, the department could initiate a process for 100 borrowers, and an administrative law judge, after going through this fulsome process, could make the determination that there was no basis for a bar defense claim. And what the department was saying is, okay, but then those individual borrowers could actually go back and file individual claims in front of a staffer, and the staffer could make a different decision. Now, I don't think at that point they would have an opportunity to recover against the school, because there would already be an administrative law judge decision on the record that would say the school's not culpable. But it does create exposure for the taxpayer, right? Because every time a group claim fails, you've got borrowers who can then go back to another party who may not be bound, presumably, would not be bound with administrative law judge's decision. Otherwise, this concept would have no meaning. So I, as a legal type, again, thought that this was a really problematic concept that was floated in BDR2. Oh, here's our secret word number 2, defense. So we're at the top of the hour, a little past actually. Here's the BTR timeline, and you guys can go through this in detail, but what it lays out is all the significant points at which the last administration started and completed BDR2, and then it also lays out when BDR3 was first introduced. That red line, some of you may immediately recognize the significance of that red line. That's the inauguration. So that represents the changeover in administration. What you'll see is BDR2 above the red line, and then the efforts to suspend BDR2 and initiate the BDR3 rulemaking below the red line. We've already talked about a lot of this. So let's get into session 3. I mentioned earlier the department made clear that negotiators are to ignore BDR2 and to essentially start from scratch, although as a practical matter, I also noted that, you know, most of us who are at the table are aware of the arguments and ideas that were in the BDR2 rulemaking, so it's very hard to expect anyone to totally disassociate from that, and the fact is that's not happening. BDR1 remains in place. The recovery action regulations from January 2017 are effective and remain in place. This was a question I specifically asked the department, and they confirmed. And then the 2016 regulations are not excluded from conversation, and that point was made as well. So the department, in advance of us showing up to negotiate this first round, issued 8 issue papers, or they gave us access to 8 issue papers. By the way, I'm going to provide you all with those issue papers. I meant to mention at the outset, immediately or soon after this session, we will make the slides available. You do not have to email me individually and ask. We will send them around. And I'm also going to attach, and we're going to send around the full set of issue papers, right? So these were the issues that the department at the higher level, you know, there were 8 papers, and these were the issues that were covered in each paper. Whether to establish a federal standard for the purpose of borrower defense claims. So back on the table, do we stick with the state or do we create a new federal standard? Developing a regulatory framework for submitting and evaluating borrower defense claims. So again, back on the table, how should this process work? Financial responsibility and administrative capability. So not so much in the way that the last administration considered it, but in the context of this rulemaking, really what they're asking is, when we have borrower defense claims or evidence of borrower defense claims, or there have been successful borrower defense claims, how should that play into our determination that an institution is financially responsible and administratively capable, which, as you all know, or at least the financial aid folks know, are 2 tent poles to financial aid eligibility for an institution. Last year, in the context of BTR 2, there was a much broader conversation about rewriting financial responsibility standards. Pre-dispute arbitration agreements, class action waivers, and internal dispute processes are back on the table, but as I'll note in a little more detail in a minute, the department, in the context of this rulemaking, has acknowledged that it does not believe it has the authority to outlaw pre-dispute arbitration clauses and class action waivers. That's in the issue papers, which you're going to get a copy of if you registered for this webinar, and the department made that clear during the negotiation. So they are still asking about alternative concepts. But whereas last year in BTR 2, the department flatly disallowed, as a condition of eligibility to participate in federal financial aid programs, they said schools cannot have pre-dispute arbitration clauses and class action waivers in contracts with students. This time around, the department says we do not believe we have the constitutional authority to do that, or at least the regulatory authority, I should say. 4 more issue papers, or 8 total. Closed school discharge is back on the table, false certification. And then finally, guarantee agency collection fees and, big breath, whether to recalculate a borrower's subsidized usage period and interest accrual when the borrower receives a discharge of a loan for which she or he has not received all of the benefit. I'm not really going to get into the last 2. Even in the negotiated rulemaking, I was relying on my colleagues who are financial aid professionals, many of whom I know are on the phone right now, including some of my fellow negotiators I saw are registered. They are much more capable of speaking to these last 2 concepts, and there were guarantee agency representatives there as well. But I will talk a bit about post-school discharge and false certification. Specifically, what I want to do is, and one other thing I wanted to mention, which has been a little bit unique here, well, that's probably not grammatically correct, which has been somewhat unusual, is the department's creation of a subcommittee. Typically in negotiated rulemaking, the committee itself, after negotiated rulemaking commences, can create a subcommittee. But here in advance, the department actually, in the Federal Register, said we're going to create a subcommittee, and we're going to go ahead and seek nominations for that subcommittee, right? And the subcommittee's purpose, you can look at the slides in more detail, but really their purpose is to reevaluate the composite score calculation and to consider whether or not there are ways that it should and could be altered, particularly given some of the changes in the FASB accounting standards that have occurred in recent years. And for nonprofit institutions in particular, although I think everyone has an interest in this, but some of these, for private nonprofits, some of these changes I think are badly needed, and their representatives have been pretty vocal. I will tell you that I think you are well represented, the institutional folks, because there are a number of very qualified folks on the subcommittee. One person was added, in fact, during session 1, who also is very qualified, and I think they will do some great work. Their recommendations will be submitted to the committee in full, and then the committee will vote on whether or not there is consensus. Okay, so what I want to do here in the last little bit is to walk through the questions that the department actually provided us in advance of session 1. So they gave us those 8 issue papers. Each issue paper, as you will see when you receive them, gives a little bit of background on the legal issue and sort of the surrounding law. But then there are a series of questions. And what we did in the context of the first session, really what it was about, apart from sort of determining our protocols and agreeing as to whether or not we would actually live stream the session, which some of you, I sort of say that jokingly, if you've been following this process, you know most of our first day was taken up with arguing over live streaming. But after we got past that, then we started getting into the issues, and what we did was we essentially marched through these questions, right? So you see up at the top it says IP1, that means issue paper 1, and then I'm going to go through the different questions that were presented by the department. So whether and how should the department establish uniform federal standard, as opposed to a standard based on applicable state law for evaluating bar defense claims? There's tended to be pretty widespread agreement that a federal standard made sense, and in part because, as I noted earlier, sort of practically speaking, a lot of folks saw an issue with the department trying to interpret state laws and decide, you know, which state laws applied and whether there was actually some sort of issue under state law. There were a couple of folks who suggested that maybe as a general matter this whole concept should be a state concept, and that claims of this sort should be managed entirely at the state level and should not even be managed by the feds, and that there could even be a constitutional issue or question there. But my impression was the momentum was leaning towards developing a federal standard. So then the question became, well, you know, what should that federal standard look like? And the department asked, if we establish a federal standard, should the definition of misrepresentation that governs a borrower's defense to repayment correspond to the definition that governs the department's own enforcement actions in 34 CFR? So interestingly enough, one of the things I'll point out here is that this question presupposes that misrepresentation will be a basis for a bar defense claim. I'm not disagreeing with that, but I talked earlier about this idea that the department can craft and direct conversation in the way that it frames questions, and you'll notice here the question again presupposes that misrepresentation will be a standard, and then asks about what that misrepresentation definition should look like. I think, and I think there are a number of us on the institutional side and others who think we should get away from using the term misrepresentation, and that's not to be cute. It's because you've got fraud standards out there in different states. You've got unfair and deceptive trade practice standards. You've got misrepresentation standards, substantial misrepresentation standards. And it's important to note that those are all really just labels. From state to state, the definitions can really change. And in some cases, they include intent or recklessness, or they may not. Typically, a fraud standard is a higher standard than misrepresentation. But then there's deceptive and unfair practices is kind of in between. But the fact is, you could have an unfair and deceptive practices standard in one state that looks almost identical to a, quote, misrepresentation standard in another state. So starting with a label can be problematic, right? I mean, one of the things that we talked about, I made this point earlier and we talked about during the rulemaking was, you know, let's set aside the label for a minute. What we need to be deciding is, you know, what kind of standard is this? Is it a fraud standard, meaning there's an intent and recklessness concept? It has the types of characteristics that are typically in a fraud standard, or is it a mistake standard, which the institutional folks, as you would imagine, think is unfair and allocates too much risk on the institutions? But what we really need to talk about is, you know, what's the standard itself, and then we can label it afterward, right? We don't even have to call it one. We could just call it the federal standard. We don't even have to use one of these traditional labels. But what the department is getting at here is setting aside what you might call it. Should it tie to misrepresentation in the current law, or should we come up with something completely new? And a lot of folks, I think, are arguing on both sides of the aisle, I think. I mean, I certainly argued pretty vigorously that I thought the current definition of misrepresentation was problematic, and that we could come up with something better, and we shouldn't be trying to repurpose it for uses of our defense. And then in terms of trying to decide exactly what the standard should be, I think it should look something more like a fraud standard, and that there should be some element of materiality, right, if not intent, in that standard. I do not believe it should be a mistake standard, because I believe that allocates too much risk on institutions. Interestingly, the next question posed by the department suggested that they might be open to a more traditional fraud standard. Should such a federal standard be based on common law fraud as a definition? And then they note, and this is in the issue paper, the restatement second of torts defines fraudulent misrepresentation as one who fraudulently makes a misrepresentation of fact, opinion, intention, or law for the purpose, which implies intent, for the purpose of inducing another to act or to refrain from action in reliance upon it, is subject to liability to the other in deceit for pecuniary loss caused to him by his justifiable reliance upon the misrepresentation. So this is a strong standard, right? I mean, it requires some sense of intent. It requires justifiable reliance, right? So there's a real materiality component here, and you can see how this is very different from the misrepresentation standard that was discussed earlier. Should this federal standard require a borrower to demonstrate a reasonable reliance on the act or omission causing injury to the borrower? Are there other definitions or requirements that could be considered? And as you would expect, we had a lot of conversation around this. I think that most people, I won't speak for everyone at the table, certainly I do not, make that clear, but it struck me that a number of people felt that it was reasonable to have a reasonable reliance standard. And remember, under BTR 2, at least when individual borrowers brought claims, it did require actual reasonable reliance, right? So that's not a new concept. What got a lot of conversation was, are there other definitions or requirements that could be considered? And, you know, I heard folks, again, throw out, I mean, the FTC has its unfair deceptive trade practices standard, and it has a concept of materiality in it, or injury. So to state a claim there really is an expectation that the injured party can show that they were injured in a material way. There are fraud standards and other standards around the country that have some sort of intent requirement. There's also often a recklessness requirement, or negligence, however you want to think about it. So it may not be that the party intended to do the harm, but they acted in a way that was reckless or negligent, and it resulted in the harm. And that's sufficient for the standard. So there's a lot of conversation around this one. There were a lot of ideas provided to the department. This is a critical concept, right? And it will be very interesting to see what the department comes up with in the way of the draft regulation, because I think that'll be sort of what we start from for the next round of discussion. What I do think is worth note is the department in the issue paper did not at any point advance the notion of a judgment or a breach of contract as a basis for a bar defense claim, and it was those concepts were mentioned a couple of times, but they really were not discussed at length, which suggests to me that we may be moving in the direction of a more simplified, I don't want to say simplistic, but a more simplified single sort of federal standard, which, again, if you read between the lines here, I think the department is fishing for something that's somewhere between fraud and misrepresentation. Here's your third secret word: negotiated. All right, negotiated. What should be the burden of persuasion for a borrower's claim? In fraud cases, and this is an important question, right? So you have the standard. Now, what is the burden of proof or persuasion for the standard? And the two that were sort of thrown out here by the department are clear, convincing, and preponderance of the evidence. Clear and convincing, I usually think about as sort of a 75 to 80% standard, with beyond a shadow of a doubt being, you know, sort of 95 to 100. Or I guess 100, and then preponderance of the evidence is 51%, right? More likely yes than no. And you can see that these in common law and traditional jurisprudence, fraud cases often require clear and convincing, but consumer protection laws, which is a lot of those unfair trade practices, misrepresentation type standards, require preponderance of the evidence. So this is going to be an important point for conversation. I don't feel like we talked about it a little bit. I don't know that, and folks sort of lined up on their views. I don't know that there were a lot of really lengthy or creative arguments or rationales offered. And so it would not surprise me if we see this discussed at more length along with a lot of other things in the future. What factors should the department consider when determining the amount of relief a borrower should receive? So now we've got the standard, and we moved on to the burden of proof. And now we've got this idea of, and the department seemed to acknowledge, and most parties, certainly institutional representatives, seem to agree that there should be the ability for the department to grant partial relief. There were some folks who felt that in every instance, if the determination was made that a person had a valid claim, you should be able to grant, or you should always grant full relief. But then the department sort of asked this question, which is a good one. If we're going to be able to grant partial relief, how do we decide how much to grant? And I will tell you, I think this is one of the most complicated questions. I don't know that it will take up the most time, but figuring out, I mean, and there's some questions or some theories that were advanced, you know, if the act or omission occurred in the fourth of 4 terms,
then the relief should only relate to loans made during that 4th term. I mean, there were some sort of quantitative line drawing type approaches, but I think there will be a lot more that's discussed in the future. Okay, issue paper 2, process. So the department sort of put everything back on the table. What process should a borrower follow to submit and establish a basis for a claim? What evidence should the borrower be required to provide to support the claim? And as you can imagine, you know, borrower advocates feel like there shouldn't be an unreasonable burden on the borrower, which is understandable why they would take that view. And institutional folks, I think, feel like, okay, but you shouldn't be able to just make an allegation and that be the end of it. There should have to be something more than that. So we're going to have to figure out a spot in the middle, I think. What due process and notification requirements should the department provide to an institution? So again, I mentioned at the outset, I favor a single process in front of an administrative law judge. I think you could have a staffer at the department. This is just my personal opinion, to be very clear. I think you could have a staffer at the department verify a claim that, you know, that the allegation includes the fundamental elements of the claim. But beyond that, I think any determination as to whether a discharge should occur, even for a single borrower, needs to go in front of as independent as at the Department of Education. This is no disrespect intended to the civil servants that work there in all areas, but the administrative law judges are one of the most insulated and independent units within the department, right? I mean, when you move out of that unit and you start talking about, you know, staffers, what if you're talking about political appointees? I mean, you can get to folks who are very subject to the pressures of whatever administration might be there. And I think to ensure as fair a process as possible, and if there's anything we've learned over the last year, it's that administrations and views can change pretty quickly. You know, to ensure as fair a process as possible for all the parties involved, I think we want to get the process in front of as independent tribunal as possible. And I understand that that may be more cumbersome and not as, you know, although I think there are things the department could do. You know, you could create a special unit within the administrative law judge just to manage bar defense claims. You could work on expedited or fast track processes, things like that. But I still think it needs to be a single process where both the discharge and the liability of the institution are determined, and that needs to be in as independent a setting as possible. So as you would imagine, when I'm answering these questions at the table, I mean, I'm talking very much about why this process should work this way, and a big part of it is ensuring due process for the institutionals, for my institutions, right? Because there wasn't necessarily opportunity for them to be involved at all points. And what's interesting is there were folks at the table who said and really felt, look, up until the point that the department tries to recover, the institution doesn't have an interest. And again, my view is from the moment a borrower brings a claim, that is not just a proceeding between the borrower and the department, right? I mean, the institution has an interest immediately because the department claims a right to recover from the institution for any amounts that might be discharged. Administrative capability and financial responsibility. I alluded to this earlier. Under what conditions or to what extent should institutions incur liability for reimbursement of borrower defense claims? And we talked a little bit about that, and I think there will be a lot more conversation. What's interesting is, though the department did not pose, and you'll see I'll just put the other question up here too, the department require posting of sureties when you have borrower defense claims, what metrics should be used when making these determinations. So the department really doesn't stray, again, beyond the notion of borrower defense claims, but the conversation pretty rapidly strayed into are there reportable events beyond borrower defense claims that also could be deemed a basis for financial responsibility action on the part of the department, which, as you who paid attention last year know, was a big chunk of BDR2. There was a whole new framework put in place that sort of revolved around that idea. Here, the department really did not ask those questions, but certain individuals sort of started steering the conversation in that direction and brought them up, so they were discussed. I'll point out here on pre-dispute waivers, apart from an outright prohibition on the use of pre-dispute arbitration agreements, so the department, again, has essentially acknowledged that they cannot do that. Are there other measures in this area that the department could take to promote the interests of borrowers? This sort of skunked the committee, in my view. I think, you know, there were folks who said, well, we think you should be able to, you know, outlaw pre-dispute arbitration agreements, and we really don't think there are suitable alternatives. And I don't think the folks on the institutional side were real enthused about recommending alternatives. So there wasn't really a lot of meaningful conversation around alternatives that might actually be out there. At least that was my view. Should the department regulate schools' internal dispute resolution processes? This is sort of new. I didn't feel like the department really got into this last year in BDR2. Maybe I missed it and they did, but here we talked a little bit about it, and I think a number of folks felt that that did not necessarily make sense, and that was sort of getting beyond what the department really is capable of doing and doing well. And then finally, closed school loan discharge. I mentioned that this was still on the table, and the department was talking about, and these are important concepts. We're sort of tight on time now, as is my want sometimes. I have gone a little long. But I do encourage you to review these slides, because one of the things the department is thinking about is, should we extend the period prior to the closure of a school, and remember that means a branch or additional location, during which folks who dropped could still seek a closed school loan discharge. And that's an important concept, right, for schools that may be closing a branch or a location somewhere. We talked about this at some length, and I think that we'll be circling, back around both the closed school loan discharge and also to false certification, and sort of what other types of events might be a basis for a false certification discharge as well. So all the slides are coming out. You can take a little more time to ruminate on those and also look through the issue papers in a little more detail. As always, here at the end, I like to plug our blog. Feel free to read it if you have time. And here are the dates for our next 2 or 3 sessions. So that brings us to exactly 1:30. I'm looking over, and remarkably, I don't think we actually have any questions, or maybe not remarkably. But if you have borrower defense questions or you have feedback for me, particularly, again, if you're, I'm interested in what anybody has to say, and I mean that sincerely, but if you are one of those folks that I'm representing, meaning an attorney or compliance officer in particular, I welcome your feedback. And I encourage everyone to listen on to the next couple of sessions, and we'll get further updates. We'll really start getting into the details, I think, because we'll have draft language from the department, and we'll be able to spend a little more time talking about the nature of the negotiations. I hope everyone is well and has a safe and happy holiday season, and look forward to meeting with you again in January.